Good afternoon. I'm Alexis Hall, Acting Program Director for the Division of Examinations Technology Controls Program. Before we begin, I'm required to provide our standard disclaimer on behalf of myself and today's speakers that the views expressed today are provided in our official capacities, but do not necessarily reflect the views of the Commission, the Commissioners, or other members of the staff. I'd like to welcome you to our second Compliance Outreach Program on Regulation SP. The Division of Examinations Compliance Outreach Programs are designed to provide a forum to discuss compliance issues in a practical way, share experiences, and learn about effective compliance practices. For today's event, staff from the Divisions of Trading and Markets and Examinations will cover the new Regulation SP requirements as they pertain to transfer agents, discuss what to expect when interacting with an exam team, and answer any remaining compliance-related questions. We did receive a number of questions ahead of today's event, and we've done our best to incorporate responses to those questions in our prepared remarks. However, if there are still areas that you would like further clarification on, please send an email to complianceoutreach@sec.gov, and we'll do our best to answer them during the last 15 minutes of the webinar. I look forward to today's discussion and to continuing to move forward to promote compliance together. Now, please welcome Keith Cassidy, the Acting Director of the Division of Examinations, to officially kick off the event.
Thanks, Alexis. Good afternoon and good morning to those connecting from the West Coast. Thank you for joining us. Your engagement here signifies your dedication and commitment to compliance, and we truly appreciate your participation. Today is the second in a series of outreach events focused on assisting registrants in preparing for compliance with the Commission's recent enhancements to Regulation SP. This past September, we held our first Reg SP compliance outreach event, which focused on large firms. Today's program is designed specifically for transfer agents, and in the not-too-distant future, we plan to conduct a third event focusing on assisting small firms' compliance. At the outset, I'd want to acknowledge the hard work and diligence that each of you brings to your roles every day. Transfer agents are a cornerstone of the financial industry, and your contributions are vital to the market's overall success. At today's webinar, the team will discuss both new Regulation SP amendments and what to expect during a TA examination where Regulation SP is in scope. For the first panel, entitled Historical Discussion of Regulation SP and the New Rule Provisions, the panelists will discuss the history of the regulation, including an overview of the core aspects of the regulatory framework and past risk alerts on the subject. The panel will also discuss the rule amendments, which entities are subject to Regulation SP, incident response program expectations, and SEC perspectives on the monitoring process. For our second panel, entitled Exams Approach Moving Forward, the panelists will provide SEC perspectives on the examination lifecycle for entities subject to Regulation SP, including the expected maintenance and production of certain policies, procedures, books, and records. Before we jump in, allow me to also thank my colleagues in the Divisions of Examinations and Trading and Markets. An event like today's does not just happen. It requires the hard work of many dedicated individuals. So thank you, members of my team, for setting this up. I would also like to preemptively thank our panelists. They are here to share their expertise and answer any questions you have submitted. Our division is committed to supporting you in protecting your customers' information. We are here to help you with the knowledge, provide you with the knowledge and tools needed to comply with Regulation SP with that goal in mind. So thank you once again for joining us, and now over to Joe Murphy to introduce our first panel.
Great, thank you, Keith, for the introduction. I'd like to welcome everyone to today's first panel on the compliance outreach event on Regulation SP for transfer agents. The first panel will cover a brief history of Regulation SP and discuss the new amendments that the Commission adopted last year and how they impact transfer agents. Before we get started, as a reminder, if you'd like to submit a question, please send an email to complianceoutreach@sec.gov. Also, we are recording today's event, and the recording will be available on SEC's website in the next 1 to 2 weeks. Now for brief introductions, I am the moderator for the first panel. My name is Joe Murphy, and I am the Senior Regulatory Counsel in the Division of Examinations Technology Controls Program. And today I'm joined by two panelists from our Division of Trading and Markets. To my right is Moshe Rothman, Assistant Director in the Division of Trading and Markets, Office of Clearance and Settlement, and James Wintering, Special Counsel in the Division of Trading and Markets, Office of Chief Counsel. Thank you both for being here today. So, Moshe, I'd like to start with you. Before we discuss the new amendments, could you please provide a brief history on Regulation SP?
Sure, Joe. Happy to do that. So Regulation SP, I'll call it Reg SP probably for short, but it's a set of privacy rules that govern the treatment of certain non-public information, personal information about consumers, and certain financial institutions. It was originally adopted in 2000 pursuant to the Graham-Leach-Bliley Act. And then it was amended in 2003 pursuant to the Fair and Accurate Credit Transactions Act, or FACT Act, of 2003. I'll call those two amendments together the original version, just for shorthand. But originally it consisted of two components, a safeguard rule and a disposal rule. So the safeguard rule applied to brokers, dealers, investment companies, and registered investment advisors. Importantly for this audience, I think it did not apply to transfer agents at all. And it required those entities that were covered by the safeguards rule to adopt written policies and procedures to safeguard customer records and information. The second aspect, the disposal rule, did apply to transfer agents, but only SEC registered transfer agents. It did not apply to bank registered transfer agents, for example. It also applied to those same other entities I mentioned, brokers, dealers, investment companies, and registered investment advisors. The disposal rule required the proper disposal of consumer report information in a manner that protected against unauthorized access to or use of that information. It also required covered entities to implement privacy policy notice and opt-out provisions, which Congress subsequently amended in the 2015 Fixing America's Surface Transportation Act, or FAST Act. I think one thing to note here is although Reg SP is often discussed in the context of cybersecurity, it applies both to physical and digital records and information. That's true of the amendments that we're going to talk about today as well.
Great, thank you. So, Jim, could you provide us a brief overview of the new 2024 amendments to Regulation SP?
Absolutely, thanks, Joe. So the Commission adopted the amendments in May 2024, and they became effective in August of 2024. The compliance dates for the new amendments are the larger entities already kicked in on December 3rd, 2025, and then the smaller entities will be next year on June 3rd, 2026. A transfer agent for this crowd is defined under the Regulatory Flexibility Act and is a small entity if it received less than 500 items for transfer and less than 500 items for processing during the preceding 6 months, transferred items only of issuers that are smaller entities, maintained master shareholder files that in the aggregate contained less than 1,000 shareholder accounts, or was named transfer agent for less than 1,000 shareholder accounts at all times during the preceding fiscal year, and is not affiliated with any person that is not a small entity. All other transfer agents are larger entities for the purpose of the rule, and as mentioned, the rule would already be in effect for you. The amendments extend both the safeguards rule and the disposal rule to all registered transfer agents, both the SEC registered and bank registered. It also requires brokers, dealers, investment companies, investment advisors registered with the Commission, funding portals, and all registered transfer agents to adopt written policies and procedures for incident response programs to address the unauthorized access to or use of customer information, and includes providing timely notification to individuals affected by an incident involving sensitive customer information, with details about the incident and information to help the affected individuals respond appropriately. The amendments additionally expand and align the safeguards and disposal rules to cover both non-public personal information that a covered institution collects about its own customers, and non-public personal information it receives from another financial institution about customers of that financial institution. Further, the amendments require covered institutions to make and maintain written records documenting compliance with the requirements of the safeguards and disposal rules. And finally, given that transfer agents' clients generally are the issuers whose securities are held by investors, for transfer agents, we've defined the term customers under the rule as any natural person who is a security holder of an issuer for which the transfer agent acts or has acted as a transfer agent.
Great. So sticking with you, Jim, you briefly covered this, but could you discuss the purpose and overall requirements for incident response programs and the new customer notification requirement?
Sure, absolutely. So, as mentioned before, as part of a covered institution's safeguards rule requirements, they will now be required to develop, implement, and maintain written policies and procedures for an incident response program that is reasonably designed to detect, respond to, and recover from unauthorized access to or use of customer information. These P&Ps must include procedures for the covered institution to assess the nature and scope of any such incident, take steps to contain and control that incident to prevent further unauthorized access or use, and where applicable, provide customer notifications to individuals whose sensitive customer information was or is reasonably likely to have been accessed or used without authorization. Customer information is a broad term, and under the rule for transfer agents, this means any record containing non-public personal information identified with any natural person who is a security holder of an issuer for which the transfer agent acts or has acted as a transfer agent, that is in the possession of a transfer agent, or that is handled or maintained by the transfer agent or on its behalf. Now, specific to the customer notification requirement, as part of the incident response program, covered institutions have this requirement to notify customers where such an incident has occurred. You must notify affected individuals whose sensitive customer information was or is reasonably likely to have been accessed or used without authorization. Sensitive customer information is a subset of customer information itself that either alone or in conjunction with other information could create a reasonably likely risk of substantial harm or inconvenience to an individual identified with the information if it were compromised. Specific examples of this sensitive customer information include information that uniquely identifies an individual that is reasonably likely to be used as a means of authenticating that individual's identity. So that would include like a social security number, as well as information identifying an individual or the individual's account, such as a username or account number, in combination with the other information that could be used to gain access to a customer's account, such as a security code or a credit card expiration date. Within this customer notification requirement, you must provide notice as soon as practicable, but not later than 30 days after becoming aware that unauthorized access to or use of customer information has occurred or is reasonably likely to have occurred, except under certain circumstances. Covered institutions can rebut the notification requirement, the presumption. Notice will not be required if a covered institution has determined after a reasonable investigation of the facts and circumstances that the sensitive customer information has not been and is not reasonably likely to be used in a manner that would result in substantial harm or inconvenience. The way to think about this is that it's something of an outer bound date. So you would have to reach this determination within the 30-day time frame. A covered institution cannot avoid this notification obligation in cases where the investigation's results are inconclusive, though, where it is reasonably likely that there has been an incident of unauthorized access or use of customer information, and the covered institution can't figure out whether or not what specific individual's sensitive customer information has been breached. The covered institution must provide notice to all individuals whose sensitive customer information resided in the customer information system that was subject to the breach. These provisions are supposed to work together to avoid the cost and anxiety of unnecessary notifications where there is clearly no harm, but to otherwise ensure that where there is a risk of harm, the customers have the information necessary to make their own determinations about what steps they need to take. Additionally, the final amendments permit covered institutions to delay providing notice after the Commission receives a written request from the Attorney General that this notice poses a substantial risk to national security or public safety. The notices must include details about the incident, the breach data, and how affected individuals can respond to the breach to protect themselves. Also, please note that the rules are fairly broad in their scope. These requirements extend not only to sensitive customer information a covered institution receives from its own customers, but as mentioned before, the customers of other financial institutions that has been provided to the covered institution. The rules also continue to apply to sensitive customer information that is handled or maintained on behalf of a covered institution, such as instances where customer information is maintained at a covered institution's service provider.
Great. Thanks, Jim, for that detailed explanation. That was great. Moshe, could you discuss the new requirements for the oversight of service providers?
Sure. Happy to do that. So in addition to the requirements that Jim walked through in detail, the final amendments also require covered institutions as part of their safeguards, policies, and procedures to establish, maintain, and enforce written policies and procedures reasonably designed to require oversight of service providers, including, among other things, to ensure that those service providers protect against unauthorized access to or use of customer information, and provide notification to the covered institution as soon as possible, but no later than 72 hours after becoming aware that a breach in security has occurred, resulting in unauthorized access to a customer information system maintained by the service provider. At that point, the covered institution must initiate its incident response program. One thing to note here, I think, around service providers is that covered institutions are also empowered under these amendments to enter into a written agreement with service providers to provide that customer notification where it becomes necessary. Importantly, though, the ultimate responsibility for ensuring that the notification occurs remains with the covered institution. So that responsibility cannot be farmed out to the service provider, even if a written agreement is entered into for those notifications.
Great. Thanks, Moshe. So this concludes our first panel. I want to thank Moshe and Jim for joining today. We're going to break for 2 minutes to set up for our next panel, so please stand by.
Welcome back. My name is Matthew Gutierrez, and I'm a branch chief in the Technology Controls Program in the Division of Examinations. I have the privilege of moderating our final panel discussion, which will feature 3 experienced and knowledgeable SEC exam staff. This panel will explore perspectives on the exam life cycle and the division's approach to the updated requirements of Regulation SP. We'll cover important topics like the expected maintenance and production of certain policies and procedures, books and records, and we'll even discuss some SEC risk alerts, among some other areas. But before we get started, I'd like to introduce our panelists. First, I'm pleased to introduce Sal Montemorano. Sal is a senior specialized examiner and a leading expert here at the Commission in cybersecurity. He has years of experience in IT and cybersecurity. Welcome, Sal. Next, I'm pleased to introduce Michael Good. Michael is an IT specialist examiner in the Technology Controls Program. He has years of experience here at the Commission and has a background in IT audit. Welcome, Michael.
Thanks, Matt.
Finally, I'm pleased to introduce Eric Garvey. Eric is an assistant director in the Broker-Dealer Exchange Program, or BDX, here in the Division of Exams. He has over 20 years of experience at the Commission and helps supervise the division's transfer agent exam program. Welcome, Eric.
Thank you.
Great. Well, thanks to each of you for sharing your perspectives today. And we'll go ahead and get started with our first question. So, as a result of the updates to Regulation SP, the safeguards rule will, for the first time, apply to transfer agents. And the updates will expand the disposal rule to all transfer agents, not just those registered with the Commission. So how will the Division of Exams approach these areas during our exams? Sal, can we start with you on this one?
Absolutely.
Great.
So from a technology controls program standpoint, and I want to be clear that Mike and I work in the technology controls program, so we have a little bit different focus than maybe BDX might have on examinations. We are going to look at IT operations and cybersecurity aspects of the organization. But from that standpoint, we've been reviewing investment advisors and broker-dealers for roughly 10 plus years from a technology controls standpoint. And the focus has always been on the protection of client data. That being said, with our transfer agents, we are going to look at NPI data, as mentioned earlier, of security holders held by or on behalf of the transfer agent. So with that in mind, how are we going to perform our examinations? Well, it's going to start similar to any other examination, which would be a review of policies and procedures. However, the policies and procedures we're going to be looking at are those policies and procedures that identify your IT operational environment and identify your cybersecurity environment. In other words, how do you implement your network? How do you secure your network? Once we understand those policies and procedures, we're going to look into the roles and responsibilities. Do you have internal staff? Do you have multiple staff supporting this environment? Do you outsource your staff? In many cases, we do see companies outsource their IT operations and such. So understanding that aspect of the organization is going to be something we need to incorporate into our review. Once we've covered the policies and procedures and the staffing, we're going to want to understand your network footprint. What is the makeup of the organization's networked environment or systems environment? Are you working with all of your systems in one office where the data resides in one singular office space? Or are you in a hybrid, more likely, environment where you leverage cloud services or data centers to host data storage? So we'll need to incorporate that into the components of the review as well. And the real crux of the review is going to focus on, again, that NPI data. How does the NPI data get ingested into the organization, used by the business, and then decommissioned or disposed of? And so those aspects are going to be reviewed from a technical standpoint. So for example, if the business leverages or facilitates the use of the security holder information through email, we'll look at the security controls and the configuration of the email platform. Or if it's stored in a cloud storage location, we're going to look into how that storage location's access controls are set up and things of that nature. I don't want to go too deep on the exam process, but that's a sense of where we go when looking at transfer agents with regards to the protection of NPI data.
Great. Thank you, Sal. Absolutely. Excellent. And another question to consider. What should transfer agents know about our exam process? What are some things to consider that can help make the process more effective? Eric, can we turn to you?
Sure. Thanks, Matt. Just real quick, just as Sal mentioned, some of the panelists up here are from our Technologies and Control program. I'm from BDX, and so I'm going to answer this a little bit more from a general transfer agent point of view as opposed to a TCP point of view. Next, looking at our exam authority, transfer agents are examined under, and we get our books and records under Section 17B of the Securities and Exchange Act of 1934, which is generally books and records, and we're allowed to ask for books and records of all the registrants. So we're looking at transfer agents, broker-dealers, exchanges, to name a few. And we're looking for compliance. So what we're asking for are records that we're going to look at the compliance of the federal securities laws. Before we get to actually any exam, we're going to do candidate selection. And our division is based on a risk-based program. So we look at all transfer agents based on the risk profile of that transfer agent. So what's the risk profile? So there's lots of different organizational types of transfer agents. It might be a bank transfer agent, a mutual fund transfer agent, issuer transfer agent, professional transfer agent, and then the securities that the transfer agent might service varies. We have equities, we have debt, we have mutual fund securities, penny stock securities, and all those have different types of risk profiles. We're also looking to see length of time since the last exam, or if the registrant has never been examined. So all that goes into the risk profile of the candidate and determines of when we're going to select the firm. Once we select the firm, we're going to scope out the exam, and that just goes into what exactly are we looking at during the exam. So we're going to look at a number of different areas, and a lot of that's based on the type of transfer agent you are. So a mutual fund transfer agent, we might look at mutual fund operations. If you're a bank debt paying agent, we might look at paying agent services that you provide for the issuers. If it's penny stock, we're going to look heavily at how penny stocks are being transferred. So it's all scoped differently. And now with the new rules, we'll definitely be looking to scope in Reg SP at some point in the exam. We received a number of questions. Are we going to be looking solely at Reg SP during our exams? And the answer to that is no. There are some exams that we might not scope it into if it's a cause exam, for example, based on a referral. But for the most part, since this is a new rule, we will be looking to scope in the exam. For larger transfer agents, now that it's after December 3rd, we'll be looking more at a compliance point of view. And smaller transfer agents before June 3rd, we'll be looking at seeing how prepared the transfer agents are, not looking for compliance, but more of awareness. Once we've identified a transfer agent, now we're going to go into the actual exam. We'll announce the exam. We'll contact the chief compliance officer, or if there is a smaller firm, maybe the president or the CEO of the firm, to announce it. And then we're going to send out an initial document request, and that's going to be asking for documents. And most of the documents that we're going to be asking for are ones that a transfer agent should have readily available. And we'll ask for around 2 weeks to have those documents provided. Once we receive the documents, we'll start reviewing those documents. We'll most likely need to go back and ask for additional documents throughout the exam. It's rare that we'll be able to do that during one request. And then we'll want to schedule some interviews. If it's an on-site exam, if we go on-site, we'll probably do those while we're actually visiting the firm. And we might want to go on-site for a number of different reasons, especially, for example, if the transfer agent is dealing with certificates, we might want to inspect the vault, for example, so we may want to go on site. Other exams are just going to be correspondence, and then we'll do our interviews just through a video conference or a phone call even. Once we've done our interviews and we've kind of reviewed all the documents, we'll start coming up with our findings. And our findings, if we have them, will kind of fall into two buckets. They're either going to be deficiencies or violations of securities laws, or a weakness in where there's activities at the transfer agent that, if not corrected, may lead to future violations. Once we've identified those, we're going to schedule an exit interview, and that will be with the firm to go over at a high level the findings that we have, and at the end of that interview, we'll send forth what we call a findings letter with lists all the deficiencies and weaknesses, at which point the transfer agent will have 30 days to respond in writing. And that's the exam in a nutshell.
Thank you, Eric. Great overview. And so switching gears a little bit, transfer agents, they face many of the same risks of data system breaches or failures as other market participants. So how will the Division of Exams approach examining how transfer agents identify and manage these risks?
Sure, I'll take that, Matt. So from a risk management standpoint, we do hope that companies will implement a risk management program that assesses risk across the different business lines. When implementing this risk management program, or if you've already done so, we are going to look at the documented process and the documented risks to determine if you've covered all aspects of risk within the business. And obviously it's going to be different based on the size and services that your business is offering. So in many cases we see risks identified via the lines of business. They don't always go as deep as we would hope they go to cover cybersecurity and IT operations. Again, from technology controls, we're going to look at those technology risks, if you will, and the cybersecurity risks. So we're hoping that you don't only look at the business line from an operational standpoint, but from a resiliency and uptime and recovery capability. So if we talk about risk management, we want to talk about identification, how you assess those risks, and then how you mitigate those risks. So I just touched on identification, and we're hoping you hit it from a technology standpoint as well. When we talk about assessing the risk, we would want to understand how you've categorized those risks, whether they're critical, high, medium, low, moderate, low. There's any number of ways to assess the criticality. And then how you've determined to mitigate those risks. Are you going to implement a number of controls around each identified risk to lower the risk rating, hopefully within the company's risk tolerance? Or are you going to look to avoid the risk, move a service or stop performing a service because the risks are just too high for that given service? I know I'm talking a little bit abstractly, but the idea is that can you move from a process or a function that you're performing away to avoid a given risk? And then the last option would be to accept the risk. Is the risk rated low enough that if something does happen, it's not going to be impactful to the company, or is the risk so low that the odds of it happening are just very minimal and you're going to accept that risk? So once you've gone through that workflow, we also want to see, again, I think I touched on this up front, that it's documented, but it's not a set and forget. It's going to be an iterative process where you'll identify your risks, you'll identify the mitigating controls, and then you'll review that. Risks change on an annual basis, if not more frequently. And of course, lines of service. You may offer some new business function that basically introduces new risks to the business. So from that perspective, we do want to see an iterative process in the risk management program as well. And hopefully I think that covers all aspects.
Great, thanks. Thanks, Al. and to remind firms of their obligations under the federal securities laws and help them improve their systems, their policies, and procedures, the division issues risk alerts. And so what are some risk alerts that transfer agents can consider reviewing as they engage in their risk identification process? Michael, can we turn to you?
Yeah, Matt. So, I think it's really important for transfer agents to realize that, we've created a number of risk alerts. These really represent, a lot of our observations that we made through a lot of exams and things we really want to share with the public. And so, again, I would encourage transfer agents to really look at all of them, but in particular, I do want to call out some that are specifically related to Regulation SP. For example, one that we published back in 2023, safeguarding customer records and information at branch offices. This is a risk alert that really highlights observations pertaining to vendor management, data classification, technology risk, email configurations, and access management. And then we've got another set, of risk alerts related to various cybersecurity threats and topics, things like ransomware, electronic investment advice, and third-party security features. In particular, I might call out our safeguarding customer records and information and network storage, use of third-party security features. Then we've got a couple from our cybersecurity series, cybersecurity ransomware alerts. We've also got cybersecurity safeguarding client accounts against credential compromise. And then we've also got our observations from examinations of advisors that provide electronic investment advice. And then that's also followed up by our cybersecurity and resiliency observations. And this really highlights quite a few practices that firms could consider based on observations from prior examinations. So, really the key, I think, here for us is that, transfer agents should know that, from a protection of customer records and information, that's something that's very important to the division, and that's really a focus of our examinations. And so as you consider risk to your environment and things you want to do to comply with Regulation SP, we'd really recommend, looking at these risk alerts as a key tool to help you do that.
Great. Yeah, great resources for our audience to consider. Thanks, Michael.
Yep.
Excellent. And transfer agents, they have different record-keeping requirements compared to other market participants. So what are some areas that transfer agents should document when thinking about the updated requirements to Reg SP? Eric, can we turn to you for this?
Sure, man, thanks. So I think it's imperative for transfer agents now under this new rule to really reflect on their business model and where there might be security holder information. This is very new. So, there are, as Moshe mentioned earlier, the security holder information can be in many different formats. It could be both paper, physical, and also electronic. And we know that transfer agents, although the amount and percentage of work that's coming in through physical certificates has dropped, that's still a piece of the business. And so transfer agents are going to want to be aware of how that information is coming in. And there are already some rules around safeguarding certificates and disposal of certificates. We'll have to see how that gets dovetailed into the larger Reg SP procedures. Then we have electronic records, and there's lots of different ways for transfer agents to think of this. There's both records that they need to keep by the rules, so example, mass security holder files, transfer logs. These are records that transfer agents are going to keep that might have those records on it. So they're going to want to see how those can be safeguarded and then later disposed of. But we also think about transfer agents. They do a lot of other business lines depending on the services they provide. That might still include that security holder business. So they might be in the business of sending out proxy materials. They might be sending tax forms. Or they might be sending information to a vendor, for example, security holder information to a law security holder search firm to do searches for them. So a transfer agent's really going to need to sit there and think, where is all the places that we have the security holder information? At that point, that's when you think you would start doing drafting for the security holder procedures under the rule. And this is going to be an area that we're going to be focused on as an exam program to come in and really review written procedures and make sure they're tailored specifically to the business line. We have had examples in the past where we'll go in and look at procedures from a firm that might more or less just reiterate what the rule is or even copy the rule. That's not what we're really looking for here. We need the transfer agents to really reflect on their business and kind of tailor it to the business itself. As mentioned before, one of the big areas of focus is the incident response program. And this is really new as well. I imagine there's a lot of transfer agents, larger ones in particular, that have procedures that are kind of best business practices prior to Reg SP coming into effect, where they're trying to safeguard information that they have. This just makes sense that they would have that. But it might not be specifically tailored or have an incident response program. So we want to go in and make sure that the incident response program, once again, is tailored to the business that the transfer agent has. Disposal rule also is something that we're going to be looking for, the procedures for a disposal rule. As I mentioned earlier, there's 1780-19 that talks about disposal of certificates, but this is really looking at all the other disposal for all the electronic records and how the transfer agent is disposing of that information. Is there certain time frames that they're looking at? So things that we want to see from the written procedures. Looking more specifically at the incident response program, a lot of the records you want to keep are going to happen if there is actually an unauthorized breach into the sensitive data of a transfer agent. How is that documented? When did the transfer agent learn of that? Then how is that mitigated? Was the transfer agent done to control and contain that breach of information? Once the event is actually passed, we're going to want to see documentation of how the transfer agent has assessed the nature and scope of that breach. How did it happen? How many accounts have actually been compromised? This is something that we're going to want to see detailed records of to make sure we understand the transfer agent understands what occurred. And finally, when it comes to notifications, that's really new. We're going to want to see detailed records around the notifications that went out, or if there wasn't a determination, or if there's a determination not to send notifications, detailed documentation of how the transfer agent came about that decision. Finally, it's been mentioned a couple times, but there's a lot of records that may be maintained if you're using a service provider or a vendor of sorts. Different transfer agents might be used in a co-transfer agent or a service provider transfer agent relationship. And as a covered institution, that might be easier because those institutions are also going to need their own Reg SP procedures. But as I mentioned earlier, I know a common vendor that's used is law security holder search firms that won't be covered. So this is an area that you're definitely going to want to may have good contracts and an understanding of how that search firm is safeguarding that data and how they're going to report events if there happens to be a breach of their records.
Great, thank you, Eric.
Yeah, and if I could, Matt, I just want to tie in with what Eric was mentioning with incident response. If we think about incident response, the National Institute for Standards and Technology, NIST, has their cybersecurity framework. And from an examination standpoint, we leverage the cybersecurity framework to kind of scope in all aspects of incident response. And please don't get me wrong, I'm not saying you have to comply with the NIST cybersecurity framework or adhere to it directly, but it does cover different aspects of incident response. So if you think about it, it has the identification, protection, detection, response, and recover. So if you think, when you're talking about identify, you want to identify all of your assets that would be potentially compromised or potentially needs to be secured. You want to protect those assets, then have the monitoring capability to detect any potential attacks or anomalous behavior on those assets, and then have that functionality to respond and recover. So again, Eric touched on a lot of aspects and data points that we might need from an incident response process, and I just wanted to provide a framework that does help facilitate that process.
Thanks, Al.
Great. Thank you, Sal. Excellent. And so I think we have time for a few more questions. And so what are some practices that transfer agents can consider as they prepare for the compliance date?
Yeah, so I think there are a number of things that that transfer agents can do. So I think number one, that starts with reviewing and understanding the requirements of Regulation SP. And then you also want to make sure that you're engaging with stakeholders, both within your organization and if you're leveraging service providers as well. And then you also want to make sure that you're really leveraging expertise from many different areas. So that could be compliance, information technology, legal, for example. Again, so you're getting all of those different perspectives as you're thinking about how do we comply. And then you also, again, want to make sure your policies and procedures align with the new requirements of Reg SP. And then you also want to make sure that how you implement those things and your processes around those are things that you're considering as well. Again, you also want to make sure you're testing those policies and processes, again, to make sure that they're well designed and operating effectively. And then you want to make sure that education is also a key component of this, to make sure that everyone understands their part and any new responsibilities as a part of complying with the regulation. And then finally, again, just as you probably heard, big theme, if you are leveraging service providers, make sure that they understand those requirements and that they're also working to meet your expectations as well.
Great, thanks, Michael. And what are some activities that the division is considering in preparation for the updates to Reg SP?
Sure. And what I'll do is I'll reference our FY 2026 priorities. So as noted in the 26 priorities, we continue to focus on cybersecurity, which is included within Regulation SP and the protection of client data. So that'll be an annual priority for us, as it's been for the past couple of years. The FY 26 priorities also mention our plans to engage with firms in understanding their progress in preparing for the incident response program in accordance with the amendments. That remains to be our plan, to continue to engage and determine the status, even though we had a delay with the federal shutdown. So while the division continues to conduct exams under Regulation SP, this fiscal year, we are not assessing the compliance of the Reg SP amendment. Rather, we're looking at the progress firms are making towards implementing policies and procedures in compliance with the new amendment. So hopefully that helps.
Great. Well, that does conclude our second panel. I'd like to thank Sal, Michael, and Eric for their valuable insights. And now we'll take a brief 2-minute break before welcoming our first set of panelists back on the stage for the question and answer portion. Thank you very much.
Welcome back. For this last section, we invited our panelists back to the stage to answer some of the questions we've received, so I will hop right in. The release notes the expanded use of technology at registrants that are subject to Regulation SP. Transfer agents' records can be in both physical and electronic form, but more recently they've been storing data electronically, perhaps on-premise, but increasingly off-premise, such as with a third-party service provider in the cloud. What are some risks that transfer agents can consider when storing electronic records off-premise, such as a cloud service provider?
I'll take that one, Alexis, I guess. Sure. So from cloud service providers, if you're storing data in this environment, obviously you're going to want to look at the contract that you have with the cloud service provider. You want to hopefully ensure that service provider is going to be able to provide the proper response time. They will notify you if there are any issues, any incidents or breaches to some extent. But that being said, not only do you have to work on that contract, when you're leveraging cloud service providers, there's going to be controls that the firm will implement in the cloud environment, and there's going to be some controls that the cloud service provider will implement. You need to understand that balance and what requirements you may have to secure that environment. There's a lot of different variations of how you can use a cloud environment. Maybe it's a multi-tenant where there's multiple clients using a instance of the service, or where you have full access to this environment. But the point is that you need to ensure that you're protecting that environment and monitoring that environment to the extent you have the capability to, based on the services that you're leveraging from that vendor. Additionally, you'll want to make sure you have oversight over the vendor on a regular basis to ensure they haven't changed configurations or modified configurations in a manner that might introduce risk to the data you're storing in that environment.
Oh, thank you, Sal. Mm-hmm. And can somebody clarify what constitutes a substantial risk of harm to a customer's sensitive personal information?
Yes, I'm happy to address that, Alexis. Thanks. So consistent with the approach of the banking agencies, we did not define the term substantial harm or inconvenience in the rulemaking. Determining whether a given harm or inconvenience rises to the level of a substantial harm or a substantial inconvenience would depend on the particular facts and circumstances surrounding an incident. We do not intend for covered institutions to design programs and incur costs to protect customers from harms of such trivial significance that the customer would be unconcerned with remediating them. At the same time, the rules are intended to protect against unauthorized access to or use of customer records or information which could result in substantial harm or inconvenience to any customer. So there's a wide variety of ways that a data breach can injure a customer, so it would be impossible to cover all the situations on this panel. However, as noted in the release, personal injury, financial loss, expenditure of effort, or loss of time, each could constitute a substantial harm or inconvenience depending upon the particular facts and circumstances. Some examples of this harm include theft, fraud, harassment, physical harm, impersonation, intimidation, damaged reputation, impaired eligibility for credit, or the misuse of information identified with an individual to obtain a financial product or service, or to access, log into, effect a transaction in, or otherwise misuse the individual's account.
Great, thank you. Next question. What are best practices around vetting vendors or service providers according to Reg SP?
I'm happy to take this one.
Thank you.
So I think as I noted in the first panel, part of the safeguard rule is that transfer agents have to have written policies and procedures designed for oversight of their vendors. So as part of that oversight, as with any vendor, it has to start with selection and vetting. And so as with any vendor, transfer agents may want to consider the past performance of the vendor, their reputation, and their ability to provide the intended services. So is the transfer agent comfortable that the vendor can protect customer information as required under the rule? Is the transfer agent comfortable that the vendor can provide the notices required under the rule? Things like that. Importantly, policies and procedures are designed to be flexible, so they can be tailored to the specific use case that the transfer agent intends, but they're also flexible so that can change depending on how they plan to use them. So consistent with that flexibility, transfer agents can consider other mechanisms for vetting, including, for instance, a level of due diligence on the vendor, maybe ongoing monitoring of the vendor. They might consider such tools as independent certifications of the vendor or attestations from the vendor regarding their ability to perform certain services. The important thing, though, as I noted, is that the written policies and procedures must be reasonably designed. They should be tailored to the specific relationship with that vendor, the transfer agent's use case for that vendor, and they should ensure that the transfer agent can effectively oversee the vendor. So.
Thank you, that's helpful. I think we have time for one last question, and that question is how should firms demonstrate ongoing compliance versus point-in-time readiness during exams?
All right, I'll try that one, Alexis.
Thank
I think I know where that's going. So for our exams, we're going to first start out looking at the transfer agents, written policies and procedures that are currently in place. So testing for ongoing compliance will be kind of the first thing that exams are going to be looking at. We're going to make sure that the procedures actually match and are compliant with what the rule says. That's kind of the first part. In most of our exams, we're going to have a review period where we're going to look back over a certain period of time. So for example, we might go in and ask for records for up to a year. During that year, there might have been an incident that might have required an incident of unauthorized access. And that's going to require some kind of action on the behalf of the transfer agent and potentially notifications. So after we review the written policies and procedures, we're going to make sure that transfer agent's following those procedures when an incident actually happens. We want to make sure that all the records are in place and the transfer agent's really able to describe, how it was able to implement it. So we're going to look backwards and see a little bit, during that time. Other things that we might do is that the procedures mention any type of review that's supposed to occur by management or trainings. Did those actually take place throughout the year? Or during disposal, if there's a certain period where records are supposed to be disposed of or some kind of cycle, we want to go in and make sure that was done during the proper scheduling. So we'll go in to check ongoing compliance by looking at the written policies and procedures, but then test backward throughout the year during the review period to make sure those policies were fully implemented.
Thanks, Eric, and
Sure.
thanks to all of our panelists today. And thank you for joining us. We hope you found the discussion informative, and we welcome your feedback. Our next event for Regulation SP is slated for small firms, and that is towards the beginning of next year. So until then, take care.